The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, thank you. We'll proceed with the first case, United States versus Williams. And I guess, Mr. Smith, you're up.
Yes, Your Honor, thank you. And good morning to everyone. You have Nick Smith for all four appellants. They've all pled guilty to conspiracy to distribute 500 plus grams of methamphetamine without plea agreements. They all have pretty sad stories of addiction, ruining their lives. Johnson, Williams, and Bennett fell into the trade this way, not to prey on weak people. The Virginia piece of this conspiracy involves Johnson, Williams, and Bennett. They're not involved in the entry points out west. And I think we would concede, Your Honor, that appellant Ferris is somewhat differently situated in that respect. The 27 defendant conspiracy doesn't specify between ice, higher purity methamphetamine, and lower purities. And in the guidelines, the court knows that ice is the strongest currency in the table, so to speak. So 1 unit of ice gets you 10 units of a lower meth mixture. And it's not just, the comparison between ice and lower meth mixtures. 1 unit of ice gets you 2 units of heroin. So the commission's logic was that higher purities are found upstream with the kingpins, but courts around the country subsequent to when the commission last met have declined to apply that ice bump on policy grounds because it's now thought that ice has monopolized the market. And so it's not as reasonable to infer that higher purities of meth imply a kingpin type of role. So there were 2 sentencing questions for all of the appellants. One is drug quantity and type attribution. And the other was the defendants asked the court to dilute, so to speak, the 10-to-1 ice regular meth ratio on policy grounds. All of the appellants were hit with 1.5 to 4.5 kilos of ice. So the judge declined to disagree with the 10-to-1 ice disparity and attributed the entire bulk of the conspiracy's ice, the 27 defendant conspiracy's ice, to each appellant. So, Your Honors, we concede that the district court cited the correct standard for attribution under the guidelines. That's Rule 1B1.3. It's the Pinkerton standard, but our argument is between the motion and the act falls the shadow. There's a Collins case in this circuit that says the Pinkerton's analysis for drug attribution has to be individualized. And if you look at what the court did instead of what the standard was, the court's focus was on, quote, the conspiracy itself was centered on ice and defendants knew or reasonably should have known that fact, end quote. That's Joint Appendix 177. But if you go through the parts of the analysis the court followed, it was more conspiracy focused than individualized. So the first point we'd like to make is that there was testimony from a DEA task force officer named Park in all the cases where he testified that you can't, quote, eyeball the distinction between ice and lower purity meth. So that, if you could, that might have been a basis for the court to find that the appellants here had actual knowledge of what they were selling being ice, even though there were no lab tests performed on most of the appellants showing that what they possessed was ice. But that wasn't the case. So what did the court focus on? Well, it focused on kind of general.
Well, counsel, the judge, and I'm looking at the opinion from the district court. He went through defendant by defendant and talked about their involvement and the folks that they bought and sold from, most of whom pled guilty and said this was an ice meth conspiracy, and that's what their transactions were about. Why isn't that enough?
Thank you, Your Honor. So I was getting there, but it was taking me too long. So our response to that point is that the plea agreement stipulations do concede that those defendants in the larger conspiracy conceded they were dealing in ice. And the district court was correct to note that some of those individuals had interactions with the appellants in this case. But what the court did not link between those two groups was references to ice. So I think if the debate were about whether
well, if the people they were selling to said this was an ice conspiracy and that's who they got the drugs from, what else does he need to do?
So if you look at the cases that the government cites on this exact point, actual knowledge or reasonable foreseeability, there's one of two factors. One is a lab test showing ice purity taken from the actual defendant, showing that the drugs that he was selling were ice. The second factor is either the defendant himself acknowledges what he was selling was ice, or a witness testifies that I said to him this was ice. He was in a conversation where he was acknowledging this is ice. Those are the kinds of factors that the courts have relied on that Mr. Juhan has cited. Both of those are absent here. You don't have anyone testifying that these defendants said they acknowledged this was ice. You don't have any lab tests showing that what they were dealing was ice. And on the contrary, Judge, one of the tests taken from one of the appellants here shows it wasn't ice, that he was dealing in drugs that was half the percentage of ice.
But counsel, I mean, in addition to the stipulations of the individuals with whom your clients were dealing, Mr. Park testified in a way that I think links test results to showing ice level purity to all of the defendants with the exception of Johnson. Now, I realize in Bennett there was one that was less than 80%, but the others have testimony linking them to lab results that are, at the ice level of purity. Why wouldn't that justify the sentence?
Judge, we think that's right. I think we would concede that on the point where there's plenty of precedent for the principle that if a certain quantity of drugs is associated with a particular defendant and it's only, let's say only a fraction of it is ice, the court can appropriately extrapolate from that portion of what was seized from that defendant to a larger amount. I think Your Honor's correct. That's true for Appellant Williams, where the quantity tested that was seized from him was 100% pure. But Your Honor, we would just object that we do not think that's true for Johnson or Bennett. And I think Bennett is the appellant where when they tested.
Well, look, if I could interrupt you, I know I'm familiar with the test that shows the less than 80%, but I'll go back and double check. But I thought that the lab reports at 310, that the testimony or the record indicated that those were linked to him as well. I may be wrong. I'll double check that myself, but that was my memory, and that's what my notes from going over this said.
That's correct, Your Honor. So I think our response to that in the reply brief was that the government essentially used the same lab test for all four appellants, and the court, the connection between those lab test defendants and these appellants was some conversations and some interactions they might have had with each other, but there was no evidence that those conversations had anything to do with the distinction in purities. So we're not clear on what the argument is, the inference argument here is. Can we extrapolate from any kind of conversation between Mr. A and B that the subject matter is about purity? I think we would say that that's not strong enough to develop that inference, and we don't think that those cases support that inference, Your Honor. So if you cut out the stipulations in the co-conspirators' plea agreements, you're not left with much individualization here. The other kinds of logical underpinnings for it was all drug dealers know their product, and I don't think there's much support for that in the case law. The other large piece of this was, well, meth has monopolized the market. So how can you claim you're not aware of what this drug is if it's monopolized the market? Well, Your Honor, if there's only one thing in the market now, then we don't need to focus on what the properties of what that product are. It's it's just meth. That's all that exists anymore. So the claim that, you know, you should know how pure this drug is, you should know how dangerous this is, that might have made sense when the market contained multiple products and we've got to choose between one versus next on an economic basis. This one's cheaper. You get more for your bang for your buck with this one. That logic doesn't apply anymore, Your Honor. And so we think that this didn't satisfy the Collins case individualization. And we think that if this were just an academic exercise to send it back to the district court, well, then why didn't the government offer testimony from co-conspirators saying, hey, I had a conversation with Appellant Johnson. He said this is ice. We had a conversation. We were talking about meth purity. That didn't happen, and it could have. And there's a reason it didn't happen, Judge. So the other argument was about the district court's decision not to vary on policy grounds. We concede that this is a matter wholly within the discretion of the district court, and it's generally not reviewable on appeal. Our point is that there is a narrow opening where if the court decides to go out on a limb and address policy, it doesn't have to. But if it does, this court can review a factual premise of that discretionary decision-making if it's incorrect. There's no rule that says this court has to allow an incorrect premise to stand. And we think that if the court proceeds through the premises that the district court can justify the 10-to-1 disparity, they don't really hold up. You know, it is true that meth is a dangerous drug, absolutely the case. But that wouldn't explain why there's a 10-to-1 disparity between ice and meth. There were some erroneous webpage of meth facts that the court cited from a webpage, but were not appropriately sourced. And we think, you know, if you look at the government's brief, it's not actually defending those premises. The final arguments is that Appellant Johnson was scored at criminal history category 2 because the meth conspiracy, which ran from January 2016 to October 2018, overlapped by 30 days with the DUI probationary period. Mr. Johnson argued that's exactly the kind of reason that a district court might depart downward under 4A1.3. The district court didn't address the argument. We don't think it was deliberate. There were lots of issues the court was addressing at the time. And the argument is that under the blue case...
I don't understand why criminal history is less simply because the overlap is 30 days. I mean, what if the overlap was 100 days? Or what if the overlap was 1 day? He still had that criminal history. You have to draw a line as to which prior offenses you're going to consider. But he did commit the prior crimes, and he was on probation during the time of the offense. And so the fact that the overlap was only 30 days doesn't diminish the criminal history.
Your Honor, that's a very reasonable analysis of the issue. And if the court had proceeded through that analysis, I think we would have, the government's correct, that we would have no basis to challenge it on appeal. I think, but the argument is more procedural, which is the court could have gone through that analysis and decided that way. But conversely, it could also have found that this is the standard is whether it's the type of facts that might suggest that the criminal history category overstates the seriousness of the category.
I mean, your arguments about not disagreeing with the policy and not imposing a benefit on the criminal history, this isn't a case where he has to justify giving a higher sentence. He's following the guidelines. You're challenging his decision, the judge's decision, simply based on what he thinks the guidelines impose. And these divergencies from the guidelines are virtually unreviewable, it seems to me. They're judgment calls that are being made by the district judge. In both cases, in the first instance, he followed the policy. And whether he agreed or disagreed or was misinformed, the policy is the policy established by the commission. And with respect to the reduction of criminal history, he followed the guidelines again. And you're suggesting that he should have done something more beneficial. And I don't understand it, how we challenge these negative discretionary decisions.
Your Honor, I just want to make clear that on the criminal history category argument, we are not challenging the substance of anything the district court judge did. We are only challenging that it slipped between the cracks. And we don't think this was deliberate by any means. On the contrary, we think it wasn't considered because there were lots of other issues. And we think that's the type of issue that Blue says warrants a remand, just to make sure that the argument was properly considered, Your Honor. And so if there aren't any other questions, we'll
All right, thank you, Mr. Smith. Mr. Juhan?
Yes, Kegel Juhan on behalf of the United States. And if I may, I'd like to start first by addressing some of Judge Agee's questions and then addressing some of the conversation that Judge Quattlebaum began. Judge Agee, you asked about why isn't this evidence sufficient? And Mr. Smith's response was to essentially say, well, this record doesn't have direct evidence of knowledge. But of course, direct evidence of knowledge is not required. This is a circumstantial evidence case, and it's a very strong circumstantial evidence case. Additionally, I would cite to the court this court's recent opinion authored by Judge Agee in Siegler. It's a published opinion in an ICE methamphetamine conspiracy case where the court said, what we're looking at is the evidence that is in the record. We're not talking about doing for what other evidence there could be. So sure, Mr. Smith is correct. Theoretically, there could be better evidence in this case, but what we're stuck with is the record in this case, which shows that these defendants were major players in this conspiracy, that their direct co-conspirators admitted the conspiracy was about ICE, that what was seized from the conspiracy was in fact ICE, and the market that these guys were in the business, in the livelihood of supplying, preferred ICE methamphetamine. And so those are all bricks in the wall that the district court could use to find by preponderance that these defendants, each individually, knew or at least ought to have foreseen that this conspiracy involved ICE. Now, to Judge Quattlebaum, your question, you asked about, what about, I think, JA 310? JA 310 are the lab certificates of the ICE that was sent from Mr. Ferris to Miss Barrett. Now, Miss Barrett initially was the direct supplier in this conspiracy for Mr. Williams. Mr. Williams got several ounces at a time for her, and she eventually said, I don't want to keep distributing to you. I don't want to do that volume. And so the evidence is uncontested that Mr. Williams then went straight to the source out in Southern California and right to Mr. Ferris to get more methamphetamine. And so that intimate, significant involvement. Yes, Your Honor, you have a question?
I did. Was it
significant?
I'm sorry, counsel, if and maybe you're getting to this, but and I'm just trying to see if I noted this right. I'm having a little trouble getting my hands on it now. Did that lab report at JA 310, was it connected with Defendant Bennett at all?
I do not believe, Your Honor, that it was connected with Defendant Bennett. I think, I don't think it was, Your Honor. I would not swear to that. That's not my recollection of the record.
So with respect to Defendant Bennett, are there any lab results that were connected to him? I know you have the stipulation and the testimony about everyone's involvement, but are there any lab results specifically connected with Mr. Bennett or I don't know if it's
It's Mr. Your Honor.
Yeah.
No, I don't believe. My recollection is that there is not a seizure in this specific case that was lab tested and came directly from Mr. Bennett that came back as ICE. Now, there, of course, was the small quantity that was from him that was not ICE, and the district court considered that fact. It weighed that fact, and this court's opinion from 2000, it's unpublished, but from 2000 in Cockrell says, well, that's okay. The district court can do that even if there's some non-ICE seizure. And as to Mr. Bennett's significant involvement, he was getting 13 pounds of methamphetamine directly from an interstate source fronted to him by Ms. Roberson, who again agreed as part of her plea agreement that this conspiracy involved ICE. And she was getting that, in fact, from Mr. Ferris herself. And so there certainly is substantial circumstantial evidence that someone in his position, as involved as he was, ought to have known that this conspiracy was about ICE. And I'd also point out, Your Honor, JA 102 to 04, the district court had a colloquy with Mr. Bennett's counsel about that and said, you know, I think I understand this argument that maybe you'd have something to stand on if he was just some mule, but he was deeply involved in this conspiracy. And so when you add all the facts together, Your Honor, there's certainly it wasn't clearly erroneous for the district court to conclude what it did. I'd be happy to answer any other questions the court may have about any of the issues in the case.
All right, thank you, Mr. Juhan. Mr. Smith?
Thank you.
Yeah, yes, Your Honor. So Mr. Juhan just referenced, just made an argument that we can infer knowledge of ice versus lower quantity methamphetamine from the sheer bulk of the drug that some of the appellants had received. And I think our response to that is that if the question were whether the appellants knew that the drug was methamphetamine versus some other kind of drug, that is absolutely correct. The inference there is rock solid. But since the question is not whether the drug was methamphetamine, but whether there was knowledge of ice, which is a specific kind of purity that's punished much more ferociously than other kinds, I don't think bulk itself is a factor that allows you to infer purity from. So, and I think that we haven't heard from Mr. Juhan any other kind of factor that would allow the court to infer purity for the defendants from whom no seizures were made of ice. No testimony was given that the defendants mentioned selling ice or were in conversations about ice. And I don't think there's any other factor here that gets you there, Judge. So I think that's where we'll stand with our argument.
All right. Thank you for your arguments. Mr. Smith, do I understand you were court appointed?
Yes, that's right. That's right.
I want to thank you, genuinely thank you for your service. It was a very sophisticated argument, and I think your clients can be happy with that. We normally come down at this point and shake hands with counsel, and we'd love to do that. But the best we can do is extend our greetings and thank you for your arguments today. And we'll take the case under advisement and proceed to the next case.
Thank you very much, Judge.
Thank you.
Your Honor.
United States versus Coleman. All right, we have Mr. Bragg, Ms. Hudson on. Can you hear us?
Yes, Your Honor.
You hear me? Ms. Hudson, do you hear me?
Yes, I can hear Your Honor now. Thank you.
All right, we'll proceed in this case, and Mr. Bragg, you can begin.
Thank you, Your Honor. Good morning, and may it please the court. I'm Mike Bragg. I represent Devon Coleman, who was convicted on charges as described in their brief. And we're here regarding whether Judge Jones erred by failing to grant our motion to suppress the results of a search that arose on September 20th, 2017. Involves essentially a Terry stop of Mr. Coleman's vehicle. On the morning of September 20th, 2017, the assistant or vice principal of Patrick Henry High School in Washington County, Virginia, as people were beginning to appear for school, noticed a vehicle in the parking lot of the school. He checked on it, and there he noted that there was someone, an adult, asleep in that car, and also noted that there was a crossbow in the back seat. He was unable to waken the person in the car, and through that he contacted, through the sheriff's office, Deputy Cody Johnson. The school resource officer who regularly is assigned to Patrick Henry High School was off that day, Deputy Johnson was a school resource officer assigned to another school. He was at the other school, and it took him some 15 minutes or so to drive to Patrick Henry High School. When he arrived, and I think he had contact with the vice principal, he observed an older model Pontiac Sunbird sitting partly in a parking space and partly in a travel area. The brake lights were on. He stopped behind it some distance away, and as he started to get out of his car, it sounded this siren, just in a blast. The car immediately stopped.
Let me interrupt you there. At that point, that's the stop that's at issue, right? That's the Terry stop. All right, so we don't really need to know what happened after that.
One point on the crossbow, but he recited basically all the evidence that you've recited. So if we put the crossbow to the side and leave it out of the calculation for a moment, we have a circumstance where, unfortunately now in our country, school grounds are in a different context than if it's the side of the road or the convenience store parking lot. So it's clear that the defendant is not a student. The principal of the school has told him, we've been trying, we can't wake the guy up. I've seen the video. He was not parked in a parking place. He was just kind of sideways in the parking lot. Why wouldn't that, a passed out individual who has no apparent reason to be on school grounds at that time of the morning, justify a stop in and of itself, regardless of the crossbow?
As Your Honor observed, if the stop was when the moment of the stop is what is significant. So what information did the deputy have? I do not believe the deputy had, in terms of his information at that point, that it clearly was not a student. That was my point there. I don't think that was part of the calculus.
Is this a middle school?
It is a high school.
High school.
It is a high school. And
are children, is there anything in the record about children having automobiles and parking on the school grounds?
As I remember, yes, and actually you can see in the, I believe in the videos, that this was an area of general parking where at least students, any adults or parents that were coming to school for whatever reason to conduct business also would park in that area.
Does the record show how old this man was?
He was in his 30s, Your Honor, but that was not information.
Why isn't that an adult?
Well, yes, he was an adult. I'm saying that that was not information that the deputy had at the time.
Oh, he observed the man. He observed a 30-year-old, and he doesn't have to know the precise age. He just knows he's an adult.
He had not observed him to make that observation until after the
Well, let's
stop.
set that aside. Here we have a car. The officer comes upon a car that's parked askew with the engine running, a man, and he has a crossbow, and the children are coming to school, and the principal is alarmed by this to call the police. Now, why isn't that much more serious than the conduct observed in Terry, which was not criminal either? I'm assuming this is not criminal because you argue that it wasn't a crime. That's fair enough, but that doesn't eliminate the crossbow. The crossbow's still there, and the crossbow's still a lethal weapon that can kill children or hurt children. So my question is, why isn't this much more egregious than the facts in Terry? You remember the facts in Terry?
It's been a while to look at.
Let me refresh your memory. There were 3 men on the sidewalk, walking back and forth, a public sidewalk, walking back and forth in front of a store. And they would look about, and then they would look in the window, and then look back and forth, and then look about. An officer observed this conduct and concluded, based on his experience, that these people were casing the store in order to rob it. And they were not committing a crime at that point. And the Supreme Court said that was a reasonable suspicion to stop, and the officer could allay his concerns. So my suggestion here is this is much more extraordinary, where you have a man sleeping with a crossbow in a school parking lot, parked somewhat askew. Can't the officer ask what's going on? It's highly suspicious, isn't it?
Your Honor, and my response will be this: the reasonable suspicion that is required to justify the stop is that he have a reasonable suspicion that criminal activity was afoot. Therefore, in Terry,
but Terry explained criminal activity as afoot is either he's committing the crime or the officer is preventing the crime.
Exactly.
All right. So here let's put it in the category of preventing a crime.
So what reasonable suspicion of what crime would he have at that point? Now, I want to back up.
Injuring children. I just suggest pretty quickly, injuring children. That's the principal's concern. He's looking after the welfare of the children coming to school. I will make this distinction. I believe from looking at the testimony of Deputy Johnson, he was responding to the call, and his intention as he approached it was essentially making a welfare check. Had he approached the car, it was still sitting there, as it had been in the morning. Mr. Coleman was still asleep in the car. Him approaching the car and then taking whatever action was appropriate in terms of that interaction, waking him up or however, would have been totally appropriate and totally within the law. When he, at the time of this interaction, however, Mr. Coleman plainly was not still sleeping. And he was driving away. So he was leaving the parking lot. He was away.
What about that, counsel? I mean, doesn't that add to the reasonable suspicion when he's approached by an officer, he drives away? I mean, I don't think that would be enough in and of itself, but that adds to it, doesn't it?
It could under different circumstances, but the circumstances that were here was not someone running away from the officer.
Well, he was there by himself and not running away until he observed an officer getting out of the car. Isn't that right?
As the officer, I'm sorry, Your Honor, I didn't mean to interrupt you.
No, that's okay.
As the officer pulled up, his brake light was on. In other words, he either was putting his car into drive to pull away, or it was already in drive to drive away, and he was holding the car with the brake light on, with the brakes on. So it's not that he drove away in response. He was in the process of driving away as the officer arose. So at that point, there was nothing in terms of intervening to.
Well, let me ask you, what is an adult in a high school parking lot doing with a lethal weapon that's a crossbow?
In Southwest Virginia, it is not unusual for someone to have a crossbow in their vehicle.
It's not unusual for somebody to have a gun either. I'm talking about a man parked in a school parking lot with a crossbow.
Why one would have it
That's not why. I'm not asking why. I'm trying to suggest it is unusual in the context of a school parking lot to have a man sleeping with a crossbow in the back of the vehicle parked askew. I mean, You argue that that doesn't violate any crime, and I would go along with you on that. You don't need to get to that. You just need to take the facts and say, does it raise a reasonable suspicion, objectively reasonable suspicion? And this is the dialogue we're having. And I gather you're suggesting that these facts did not raise a reasonable suspicion justifying the officers allaying that suspicion.
Yeah, that is my position, Your Honor. That would not in itself give reasonable suspicion that criminal activity was afoot.
Okay, thank you very much. All right, we'll hear from Hudson. You're muted. I think you're going to have to hit the button.
Thought I had
I think
unmuted,
there
sorry.
you go. Yeah.
Thank you. Good morning, Jean Hudson for the United States. I'd like to just jump in with the point that you were making, Judge Niemeyer, at the very end of counsel's argument regarding the circumstances that have been now discussed fairly thoroughly involving the man asleep in the school parking lot. I just wanted to emphasize that in addition to those facts, the time of day was 8 o'clock or just before 8 o'clock. It was a school day, and it was, as the court has noted, a parking lot where students park. Children were coming to school that day. Kids were coming to school, as were teachers and staff, and they were coming fairly soon in relation to the time period of this particular event. So for all the reasons that the court has been referencing, it's clearly the government's view that where a man has been observed by a school authority in a car just before 8 o'clock in the morning on a school day in a high school parking lot with a crossbow in his vehicle, asleep, unable to be awakened, that those facts support the reasonable suspicion in this case for Deputy Johnson making the Terry stop that he did. In addition to that, when the officer got to the scene, Mr. Coleman drove away. And as the court has recognized, I think these facts are clear and undisputed, that the officer pulled in behind Mr. Coleman's car, parked erratically with the brake lights on, engine running, and really mostly in the travel lane, but turned as though he was going to pull into a place or perhaps had backed out of a place. But at the time the officer arrived, certainly the car was not in a parking place. Engine is running. The officer called in the license plate, and as he got out of the car, Mr. Coleman started driving away. So that behavior, in addition, evasive behavior or flight, however you want to characterize it, it unquestionably added to the reasonable suspicion.
Ms. Hudson, do you think the Terry stop occurred when the deputy initially got out of his car, or when he stopped the car after it had driven away and then got out for the second time?
I think I would say that the stop occurred when he whooped his, for lack of a better word, his siren. He didn't turn it on to stay on, but he, when the car started to drive away, certainly there's a stop at that point. And the reason I make that distinction is that from what I can tell from both the testimony and the video, I don't think the officer actually got out of the car. It appears that the door opened and he was going to get out of the car, but Mr. Coleman started to drive away so quickly, the door shuts, and I heard the siren activated at that point. So certainly at the point that the siren is activated, I think there's a Terry stop. And of course, Mr. Coleman then, I think he hit the siren twice, and then Mr. Coleman pulled into the parking space, and then the rest of the contact occurred. But I think when the officer simply pulled in behind him, he had not yet actually stopped the vehicle for these purposes, certainly when the siren happened. The government's view is that there was reasonable suspicion on multiple bases. The primary reason, as the court has already spoken about in the argument, being concerned for the safety of the children. As well, there was reasonable suspicion that Mr. Coleman was driving impaired under the influence of drugs or alcohol, simply because of these circumstances. And our view is absolutely.
Counsel, let me interrupt you there. I mean, the I'm trying to remember, did Officer Johnson, it seemed like the safety issue from being parked in the driving lane and the safety issue associated with the crossbow was the reason that Johnson articulated. Did he articulate the reason you just said about, driving under the influence? I can't recall that.
He said that he was concerned. At one point, he said he was concerned that there was somebody with a crossbow asleep that doesn't belong in the parking lot, and that he would be concerned about that. But he also said that he was, the first thing that he was concerned about, this is at JA 38, was everyone's safety. He said he was a school administrator and that the school administrator had contacted him regarding the subject being asleep or passed out. And then he said, I'm concerned for the driver's safety, the school safety, that is the students, the staff, and the faculty. So I do believe that he made reference to the state of the driver as well as the students. I don't think that he actually said the words driving impaired. He may have, but he certainly referred to the driver's safety.
Okay.
We also take the position that, as Judge Niemeyer has pointed out, the status of the crossbow under the Virginia Code is irrelevant in our view to the reasonable suspicion that exists in this case, and would ask the court to affirm the district court's decision on that basis. But of course, we've responded in our brief to Mr. Bragg's argument that the crossbow was a weapon of like kind, and take that position as well. But as we pointed out in our brief, we don't think the court has to reach that decision. The crossbow was a potentially lethal weapon in this car in the parking lot at this time of day, on this particular day, under the circumstances we've already described, and was therefore a fact that the officer absolutely rightly considered in believing that there was reasonable suspicion for the Terry stop. The district court got this right, and we'd ask this court to affirm on all those grounds. Otherwise,
All right.
I'd be happy to answer any questions from the court,
Thank you, Ms. Hudson.
and otherwise we
Mr.
rely on our brief. Thank you.
Mr. Bragg, you have some rebuttal?
Thank you, Your Honor. What occurs to me is this, and I recognize and respect the concerns that several members of the panel has expressed concerning school safety. Yeah, and it's obviously something to be taken into consideration. That's the reason I said that if the deputy had gotten there and Mr. Coleman was still asleep behind the wheel of that car, then his interaction would have been totally appropriate. But if his stopping the car was justified for him to intervene for the safety of the school, because there is a man with a crossbow in his car, a factor to be considered, who might have been asleep earlier, soundly sleeping, that would have been inconsistent with stopping the car in the parking lot. The appropriate thing to deal for the safety of the school would have been to allow the car to leave the school, to follow it, to see if he drives erratically, so that if he were under the influence of drugs or alcohol, then you follow the car and pull it over for that. If you're concerned about some violent action, do you stop the person you're worried about in a school parking lot while children are, or young people, I hate to call them children, are arriving and interact with that person? The interaction turned out to be very safe and very cordial. But if you in fact are concerned about this person is there to do violence, do you stop them from leaving and get them out in the parking lot?
But counsel, it sounds like you're saying, and you may be right, there were better courses of action that could have been taken for each of those concerns. That's not really our question, is it? Our question is there a reasonable suspicion, and if, school safety, the safety of the students and people at the school is a concern, okay, maybe you let him get off campus, but it seems like you're mixing up what's the best course of action with whether or not there's a reasonable suspicion.
I understand what Your Honor is saying, and that is not what I'm doing. I'm saying that the deputy's actions were inconsistent with that reasonable suspicion. In other words, if he truly reasonably suspected that there might be a crime afoot endangering the safety of the school on potential violent action by this person in this car, he would not have stopped him and got him out of the car.
Oh, I mean, the scenario is pretty easy. You say, okay, he's pulling away and the officer does nothing. And the fellow just goes around the block and comes back and shoots a few kids with the crossbow. And what's the public going to say about that officer?
No, I'm not saying that he just lets him drive away.
You just take the Terry facts. These three guys are walking on a public sidewalk. The officer well could have said, move along. That's none of your business. Just move along. He didn't do that. He suspected that they were planning to rob the store or break into the store. So he stopped them and frisked them. And the Supreme Court said that was criminal activity was afoot because that was a reasonably suspicious conduct that was being prevented. And here we have, I think, much more serious risks at stake. We have a man with a lethal weapon on a school parking lot at the time the kids are coming to school, and with no explanation. Now, if he's conspiring to make a statement and kill some children, as we know, that's been a problem in our society in recent years. It seems to me it's a de minimis stop for a second or two to find out what's going on is all that Terry authorizes. Now, of course, we know in this case that immediately after the stop was made and he opened the door, we now move quickly into probable cause, but that's not before us.
Yeah, and if I may just respond, Your Honor, my time is up.
Please do.
Just to clarify, I'm not saying that he would have let him go. I'm saying he would have let him leave the premises and followed him and have observed him. One, to make sure he doesn't come back. Two, to determine whether he could drive appropriately on the streets or is it dangerous.
And what's his justification for following and making sure he doesn't come back?
If he were truly suspicious,
well, that's my point. He was suspicious. He said he was.
No, he wasn't. He said that he was concerned about his safety. About primarily, it was a we look at during the trial on page.
I thought he said he was concerned about the safety of the school and the man.
He did, and then he also said during trial, question, okay, now at the time that you stopped him, did you have suspicion that something criminal was occurring? Answer, no, not exactly. What I was stopping him for.
But of course, that's not necessary under Terry, right? We agree with that?
Yes.
Okay.
What I was stopping him for is checking for his safety and making sure he'd be okay to be behind a motor vehicle and driving. Also, I wanted to get him identified. That was his answer at the trial.
Well, if you want to look at a crime, driving while impaired is another problem, isn't it?
It is.
And he could make a stop for suspecting somebody's driving while impaired.
Yes, if he's observed him driving.
Yeah. Okay.
And the final thing I just want to say is, Your Honor has referred to this crossbow as a lethal weapon. Just want to make sure this for the record. Our position is that under Virginia law, technically a crossbow is not a weapon. If the
That's
court
for that
uses
one
term
statute.
generically.
That's for that one statute which defines a weapon.
Yes,
But
Your Honor.
everybody agrees a crossbow is a weapon, right?
I would not consider.
Not under the statute. I'm talking about something that can hurt somebody and kill somebody.
Yes, Your Honor. Yeah,
Okay.
I just wanted the record to be clear what our position is. on
I
that.
understand. I understand.
Right, thank you, y'all.
All right. Yes, thank you. Mr. Bragg, you too were court appointed, do I understand?
That is correct, Your Honor.
Yeah, well, I want to thank you and recognize your assistance to the court. This, of course, is essential to make our whole system as best as we can a just system. So thank you for your service in that regard. We would normally come down and shake hands with both of you, and thank you for your, which is our tradition, and thank you for your arguments. And so we do so now. We'll invite you back another time and we'll shake hands and maybe even remember this occasion.
Thank you, Your Honor.
Thank you very much. And we'll proceed on to the next case. All right, we have Ms. Renee and Mr. Cook. Can you both hear me?
Yes.
Yes. Are you able to hear me?
Can I hear, did you just speak?
I'm Patricia Renee. Is everyone able to hear me?
Yes, I can hear you. Okay, we'll proceed. And Ms. Renee, we'll start with you.
Thank you. Good morning. My name is Patricia Renee, formerly Patricia Nagel, if that appears on any of the pleadings. I'm here today on behalf of Mr. Travis Ball, who has raised several issues for the court's review on appeal, whether or not this prosecution is one of vindictiveness, whether or not it is barred by double jeopardy, whether or not the guidelines were properly calculated, and whether or not the facts and circumstances of the case warrant a upward variance under the 3553 factors. Regarding the vindictive prosecution issue, Mr. Ball, as everyone is aware, was charged with capital murder of a police officer, Special Agent Walter, in Virginia State Court. Mr. Ball successfully negotiated a plea agreement in that case that resulted in his receiving a sentence of 36 years, and he was not prosecuted for the firearm. It is our position that as a result of that, the prosecution, the government came after the fact and charged him with the offense of possession of a firearm by a convicted felon. In this case, purely to tack on additional time to an already 36-year sentence. We base that argument on the fact that, again, Mr. Ball has successfully negotiated a pretty good plea deal for himself. The prosecution brought this, the government brought this prosecution after the state case had ended, when it had the ability to bring it in lieu of the state case, if in fact it had an interest that it wanted to vindicate. When you add to that the United States position throughout this case in terms of how it approached the calculation of the guidelines, it took inconsistent positions, specifically to get the maximum punishment it could. On the one hand, it characterized the act as murder in order to try to get the highest range of punishment.
Well, let me ask you, Mr. Ball, when his conduct violated state law and he was prosecuted and sentenced under state law, it also violated federal law, did it not?
That's correct.
Yeah, and the federal prosecutor is basically saying that the state trial did not sufficiently vindicate the federal interest. The federal interest was the use of a firearm that resulted in the murder. And so if the federal government thought that the state sentence didn't sufficiently vindicate the federal interests, couldn't the federal, well, it could anyway, but under the Pettit doctrine, the federal prosecutors, as a matter of policy, are free to pursue and vindicate the federal interests. Now, why isn't that what occurred here?
Well, that is what occurred here. Our position is that even though there's a policy with the United States to, or they give themselves permission to wait until after a state prosecution before bringing a federal one, there is nothing to prevent the government from acting in the state's stead. The federal government.
No, they could have done that. That's easily could have done that.
Exactly.
But in this case, they also could have concluded that the state should go ahead. There was a state murder charge, and hope that the state's handling of the case would vindicate the federal interests. But if it turns out that that trial didn't, there was an acquittal or whatever, happens, it can make a judgment that its interest, the federal interest in enforcing the gun violation in a murder context wasn't sufficiently vindicated. And so then it makes the decision to do so. Now, is that what you're calling vindictive?
I think there are several factors here. Number one, again.
Well, just let me ask you if your position is that that policy and the carrying out of that policy it constitutes vindictive prosecution.
I believe it does, especially that there's nothing about that policy that requires the government to wait to see what happens in state court.
Well, nothing requires the government to even prosecute. The government exercises discretion. But the question is, it can exercise if it's a reasoned discretion. In this case, the discretion was exercised because the government concluded that its interests were not sufficiently vindicated in the state trial. So the federal government, which can also prosecute, chose to do so.
Correct.
That's what happened here, isn't it?
Yes. And under the case law, though, Your Honor, under the case law,
what's your best case on that?
Okay, it's the Goodwin case and Wilson. And one of the factors in determining whether prosecution is vindictive is whether or not the government's actions occur after the state prosecution. That's exactly one of the factors. And so especially that, like I said—
I thought vindictiveness was the effort to punish somebody for exercising a legitimate right.
Correct.
And
one of the first acts—
I would think the government would say, and we'll hear from the government, that they prosecuted to punish a man for his conduct, not for exercising a right, the conduct being the shooting of an officer.
That's exactly correct. They exercised their discretion to punish him, but under the I believe it's a Goodwin case, one of the factors is the timing of the exercise of that discretion by the government. When the government exercises their discretion to exact additional punishment after a state prosecution has occurred, that becomes a presumption that then shifts the burden to the government to justify their actions. And that is because exactly what I was saying, there is no policy, law, or anything that requires the government to wait. So if they choose to wait to and they bring a prosecution because they're not happy with the sentence, and they could have gone before, because again, if they go in lieu of the state, they have discretion to bring whatever charges they want, as many charges as they want. They can vindicate their interest without waiting for the state. If they choose to wait for the state and then they prosecute, adding additional time, they have to justify that. And that's so the vindictive prosecution is not only about adding additional time, it's the timing of the prosecution as well. It's whether or not they're unhappy because the defendant has successfully avoided time that they believe is appropriate, which they could have brought the prosecution from the beginning to make sure that they get the sentence that they want. And so I'm going to just submit the rest on that. And what adds to this vindictiveness is, again, the government taking inconsistent positions in the sentencing calculations. They're trying to, on the one hand, characterize the act as murder to get a higher enhancement, and then on the other hand,
isn't that the federal interest? In other words, the
not
use
to
of
take
a firearm to murder, that's a normal guideline calculation, isn't it?
Correct. But then when they flip their position and characterize the act not as murder, but as an assault in order to get the 6th level enhancement on a victim, that is the government taking an inconsistent position on the same issue, how we characterize the act, in order to pile on, to make sure that that enhancement rises to the level of the 10 years or that they're trying to get.
Well, the sentencing guidelines call for life in this case. Under these facts, the sentencing guidelines call for life.
Again, I'm talking about...
And of course, the sentence is capped by the statute, but...
Correct. And
yeah.
I'm just, and, you know, I'll get to that. But I was just adding that as additional evidence of vindictiveness. And then, you know, again, requesting a consecutive sentence, depart an upward variance to get a consecutive sentence instead of a concurrent one. All of those factors combined support vindictiveness. And then it shifts to the government to try to explain why this is not a vindictive prosecution. Really quickly, as far as the calculations, the guideline calculations, this clearly is not a murder under conduct. The facts here suggest a sudden...
Well, I thought Mr. Ball in the state court pled to murder of a police officer, and there's lots of evidence in the record from the other officers who were there that it was a premeditated murder. I mean, I'm mystified as to how you say this was not murder.
Well, when, again, Mr. Ball is negotiating a plea agreement or plea offer in court, he was not, you know, pled not guilty, and I had a jury find that. A plea bargain under state or federal is a give and take. You're getting something, you're giving up something. He's happy to plead to the crime of murder if it's going to result in something.
Yeah, but why doesn't that end your argument here? I don't understand how you can argue against that.
Because over here, under the sentence guidelines, we're having to characterize what that conduct really means. We're not saying, okay, the guidelines suggest that we just rely on the characterization of the state. We're coming up in federal sentencing guidelines with our own characterization of that act. And they're under 2K2-1 through -4, I mean, 0.1 through 0.4, we're recharacterizing that behavior.
Yeah, so, all right, even if we go down that road, why wasn't the evidence more than sufficient to show murder?
Because when you look at the facts and circumstances, murder requires an intent to kill from the beginning, premeditation. Here,
so he pulls the gun out of his waist, yes, and brings his arm up to the man's head and shoots him point blank into the forehead.
And when does that happen?
And do you think that's not premeditated?
It's not, and let me explain why, if I may. Officer Dwayne is watching he's with the driver in the back of the car. He's watching the officer interaction with Ball. First of all, if Ball had the premeditation to commit murder, he could have shot the officer upon his approach to the car.
That's a different time. We have to look at the time he committed it. When he committed it, he pulled the gun out for some purpose, didn't he?
That is the act.
He pulled the gun out of his waist. It didn't go off accidentally.
That is the act.
He pulled it out of his waist, and he had to raise the gun to the head level and shot him in the forehead.
Correct.
Now, that's deliberate as can be, right?
That is the act. But every crime also requires a specific criminal intent. Premeditation is intent, not act. So when that is why I'm saying is,
are you contending this was an accident?
No. What I'm contending is that this is a manslaughter. It is a heat of passion upon a sudden quarrel and provocation.
You're
Thank-
suggesting
Right, but
when he took the gun and put it at his forehead at point blank, he didn't intend to kill him.
That is not what I'm saying at all.
Well,
What
if you're not saying it, then isn't that what's the conclusion that must be drawn? That he
No.
intended to kill him?
What I'm arguing is that this is evidence of heat of passion, and heat of passion negates malice, and malice is required in order to support.
right, but twice that day, the defendant had said, first, I'll end up killing something. And then he said, apparently twice to his girlfriend, if anybody gets in my way, I'm killing anybody. Why isn't that fairly clear proof of premeditation without anything else?
He didn't say, I'm going to kill an officer if he tries to arrest me. First of all, he says, I'm going to kill something, not someone. And that's
If anybody get in my way, I'm killing anybody. And the officer was in his way.
Okay, and so again, I bring the court back to the fact that led up to the killing. It's not just a moment before the trigger is pulled. Again, if he had the intent to kill the officer as he's walking towards the car, he had every opportunity to do so. If he had every opportunity to do so while interacting with the officer before he even gets out of the car. Dwayne testifies that he hears Walter's voice raised, and that was unusual for him because that didn't happen. That suggests a sudden quarrel. When he gets Ball out of the car, there is wrestling. Ball is resisting arrest. That is there's sudden provocation, and that is action in the heat of passion. His body is jammed into the car. He's pressed against it. There are activities and actions that are occurring prior to the shot, and I don't think the court can ignore that. And all of that suggests that there is not a specific intent to kill an officer because that could have occurred way before the time when that occurred. Also, Dwayne talks about being next to Walter, pressing Ball's chest into the car, and that Dwayne is taller. So if in fact, so by the time Ball wrestles his arm free and he turns and shoots, Dwayne happens to be at that height that he fires because that is where he's able to raise his arm. I guess the evidence suggests that had Walter been as tall as Dwayne, he probably would not have been able to shoot in that exact spot. So I think we have to consider all of the facts and circumstances. This, again, Ball had the opportunity to shoot to kill before we even got to the point where he shot, and he didn't. And I don't
know why that eliminates premeditation. In other words, you're arguing that premeditation must occur as early as it's possible to kill. And my suggestion is that he could have formed an intent, a complete premeditated intent when he's pressed up against the car. And when he turns, he has the first opportunity to carry it out, and did. And it seems to me that supports premeditation as much as planning ahead of the time. Although he did have these statements, he basically didn't want to go back to prison. He said, I'm going to kill anybody a mile away.
I agree with the court that premeditation can be formed at any time. That part is true. I'm also addressing the issue of the earlier statements that he made, and that his actions at the time on the scene negate those because he did not, his initial response was not to shoot.
Okay. Thank you. We'll hear from Mr. Cook. I think you're muted.
Thank you, Your Honor. I'm now unmuted. May it please the court, I'd like to start with this premeditation issue that the court was just discussing. In paragraph 14 of the PSR, which the district court adopted, the PSR says, Mr. Ball told his girlfriend that he had 4.5 years of comeback time hanging over his head, and he would shoot it out with the police before he would go back to jail. The PSR continues that Ball twice told his girlfriend, if anybody get in my way, I'm killing somebody. Then, of course, we have his text message that also corroborates that he said he would kill something, in his words. There was testimony at the sentencing from Officer Christopher Duane said there was no attempt to grab the weapon from Mr. Ball. And we know that Mr. Ball armed himself before the confrontation with the police officers, and then he shot Special Agent Walter in the head. Those facts are more than sufficient for the district court to find that this was premeditated murder. There's no claim here that the district judge made legal error in the test that he applied for determining what is first-degree murder. So we really have just a question of whether the district court's findings are clearly erroneous. And on this record, it's impossible for this court to say that the findings are clearly erroneous. So I think that addresses the murder cross-reference. I would like to turn back to unless the court has questions on the murder cross-reference, I'd like to turn back to the double jeopardy and vindictiveness claim. On the double jeopardy claim, we believe that that's controlled by Gamble. And the fact that there are distinct sovereigns here is sufficient to resolve any double jeopardy concern. In Gamble, in the Supreme Court's opinion, the court did not discuss why the government felt under the Pettit policy that there were a sufficient federal interest in that case, where Gamble, of course, there was a state prosecution for felon in possession followed by a federal prosecution for felon in possession. So they were identical crimes other than the fact of the sovereign. At the oral argument in Gamble, the government explained that its reasons for having the successive prosecution in that case was that we have an initiative for focusing on recidivist offenders under the felon in possession statute, and that is an effective strategy for reducing crime. And that was the reason the government gave under the Pettit policy for that successive prosecution. No one has ever suggested that, of course, that defendants have enforceable rights under the Pettit policy. And this court has held that there are no enforceable rights for defendants under the Pettit policy. Moreover, no court, to my knowledge, has ever suggested that if the government followed the Pettit policy, that would trigger a vindictiveness claim. And I don't see how that could be reconciled with the Supreme Court's precedent about due process claims. For example, under Medina versus California, the Supreme Court has said that it doesn't use the due process clause to alter the scope of specifically enumerated rights. And here, the specifically enumerated right would be the double jeopardy claim that the Supreme Court considered in Gamble. And so I don't think that it would be appropriate for a court to use the due process clause to try to change the contours of the double jeopardy right. But in any event, it's easy to see in this case that this is the kind of prosecution that falls within the heartland of the considerations under the Pettit policy. Pettit policy allows the government to do successive prosecutions when a case falls squarely within an enforcement priority. And as in Gamble, an enforcement priority is dealing with recidivist offenders who are particularly dangerous, who possess firearms. This defendant obviously fits that profile to a T. The Pettit policy also considers the severity of the harm. And in this case, you have the most severe harm you could have from a felon in possession violation, a murder. It also isn't just a murder, it's a murder of a police officer. And the government has a strong interest in ensuring that law enforcement is protected. Moreover, a defendant who's willing to kill a police officer shows a particularly heightened lawlessness that raises that defendant's dangerousness. So those enforcement priorities are clearly permissible under the law, and I don't think that it's possible to say that there is a unconstitutional motive at play that would trigger vindictiveness. Unless the court has other questions, I'm happy to rest on our briefs, but also more than happy to answer questions.
Thank you, Mr. Cook. Ms. Renee, you have some rebuttal?
Yes, thank you. Again, the government just keeps repeating that they have the ability to act in certain ways after the fact, but it does not explain if if they have all of these legitimate interests and they want to, vindicate these recidivist issues and stuff.
Well, I think
they wait.
If I understand correctly, I understand that the federal government, as a matter of discretion, is also willing to have the states vindicate its interests. And they apply this successive prosecution only when they conclude that its own interest, the federal interest, was not adequately vindicated or served in the state court proceeding. And so that's necessary to be successive. And of course, the Pettit policy explicitly justifies that. I don't think we should be citing that as law or reliance. We cite that as a course of policy and conduct that the prosecution takes. But it does seem that the Supreme Court was addressing right in that heartland. And in Jackson, we did the same thing. Did not find any impropriety in this type of procedure. But you're emphasizing, which is a factor, I understand that the successive prosecution can look like they're punishing a man for getting a benefit in the state court. That's your argument. And
that's correct. And
that would be pretty unfortunate. Yeah,
well,
I understand that. But the other question is, when you have separate federal and state interests, and the federal interest is not satisfied in the state prosecution or vindicated, then it's hard to attack the notion that the feds can still vindicate their interests when they see they have not yet been vindicated by the state process, and they want to have their own law enforced. That's what happened here, I think.
I always look at this as, in the situation, let's say going way back to like the Rodney King case, when the state prosecutes and, the defendant is acquitted. And then the government comes back and prosecutes and gets a conviction because they're vindicating an interest. In that situation, people may quiver with the double prosecution, but we're only getting one sentence. And so, I think that, again, the policy is not the law.
Well, you're only getting one sentence here, too.
Well, you're getting two, actually, because he already
was two different crimes.
Well, well, implicit in the use of the firearm conviction in state court is the possession of the firearm. That was the mechanism by which the officer was killed.
Except the federal crime also requires that a person be a felon, whereas the state crime does not require that he be a felon.
Well, possession of a firearm by a convicted felon in state court does require that he's a convicted felon.
Sure it does, but he was charged with murder, wasn't he?
I'm sorry. Yes, he was charged with murder, but I'm talking about the mechanism by which he committed the murder. Necessarily, he had to possess the firearm in order to carry it out. So,
but in order to, you're saying the double jeopardy or the Blockberger overlap. The notion is the state crime has to have elements that the federal crime doesn't have, and the federal crime has elements that the state crime doesn't have. And I was just pointing out that the federal crime requires that he be a felon and possess a gun, whereas the state crime does not have that element.
Well, and as far as, if I may just address that.
Yes, please, go ahead, sure.
Thank you, sir. As far as the double jeopardy, I'm also concerned with the, where does the doctrine of collateral estoppel come? If the government is able to just, use this Pettit policy to avoid the the straight up double jeopardy, double prosecutions, double sentence, does the concept of collateral estoppel have no meaning? I mean, is the Pettit policy?
Well, I think you raise a very serious point, and I think the Academy and lawyers are disagreeing whether this whole notion of double jeopardy under Gamble, before Gamble, was appropriate. I mean, I think it's a serious argument, but As you know, the Supreme Court did consider all of this pretty thoroughly in Gamble and preserved that doctrine, the two sovereigns and the two different bodies of law.
If I may just
so
really
I don't know
quickly,
if we're free to move about in that area.
just really
You think
quickly,
we're
I'm
free to-
bringing it up in terms of the government's pettit policy, because it's not a law. It's not a, that's their
No,
own
you're
internal policy.
absolutely right.
Whether or not that is basically using a policy to overturn years of precedence of the doctrine of collateral estoppel.
Thank you very much. We appreciate that.
Thank you. I submit the.
I understand, Ms. Renee, you were court appointed.
Yes, sir.
And again, I want to recognize that this is so important, and it's, of course, very important in this case. You've raised some very difficult questions. I think some of them may have been resolved by the Supreme Court, and we're not free to move around, but other parts, I understand your arguments. At this point, we would come down and greet counsel and thank you for your arguments. I can't remember whether, Ms. Renee, you've been before us, but Mr. Cook's been before us many times. We've always enjoyed his arguments. And so
I was there a year
thank
ago.
you very much.
I'm sorry, I was there a year ago under Patricia Nagel.
Oh, okay.
Thank you.
Well, thank you. Was I on a panel with you?
Yes, you were, in fact. And it
Oh,
was
my
in
gosh,
person.
I apologize that
Don't
I
worry.
haven't to recognize. And I would have clarified this when I came and shook your hand. But thank you very much. And,
Thank you.
We'll adjourn court for the day.
Okay, thank you. Have a good day.
Thank you. You too.
The Honorable Court stands adjourned until this afternoon. God save the United States and this honorable court.
Judges, I will move you to the